Lee versus Tam is a case where Michelle Quackley, the director of the Patent and Trademark Office, also known as the PTO, denied a trademark application of Mr. Simon Tam and his rock band, the Slants. All members of the Slants are Asian Americans, and they believe that they deserve to have the trademark because it is not an offensive or disparaging term, but in fact empowers them as well as empowers their fans. The Patent and Trademark Office would say that they have a two-part test when trying to decide whether a trademark application is in fact disparaging or offensive. The first part is, what does the mark mean and in what context? And number two, if it is offensive or disparaging, does it affect a substantial composite of the target population? The best argument that the government has in this case is that they followed the law to the letter. They analyzed whether the Slants could be considered offensive. In fact, they claim that they went to urbandictionary.com, and that's where they decided that it was in fact offensive. They also found that several Asian American special interest groups declared that the Slants would also be offensive. Simon Tam and his group, the Slants, however, claim that the PTO is infringing on their First Amendment rights to call their group and trademark their group whatever they want. They also claim that the PTO has been somewhat arbitrary and capricious in granting out trademarks. For example, the PTO has approved trademarks for rap groups such as NWA, other groups such as Dykes on Bikes, and groups that might be called celeb retards. The questions of whether these names are offensive or disparaging perhaps should not be left up to the government.